The aftermath of the Canadian budget and the plan tabled by the immigration minister in Parliament, together with a discussion about founders' responsibilities in an SUV application. I'm Howard Greenberg.
Hi, I'm Hameed.
Well, Noman, let's have a little chat about the immigration plan and I guess about the finance bill tabled in the House. What are you hearing?
There's a lot of discussion. Now we've had a moment to sort of digest. A lot of analysts have been talking about the fact that, it was a 380,000 target for 3 years, but these one-time processes of 33,000 TR to PR and 115,000 protected people is on top of that number. So if you do a little bit of math, we're not really at 380, are we?
So the numbers kind of don't add up the way the government was suggesting they would add up.
So in a sense, they have reduced the number. There's a lot of pressure to do it, but they've also reconciled that long-term, Canada's going to need immigrants, and they created a one-time exception which allows them to increase the number, and these would be fairly skilled individuals that are in Canada, so it reduces the backlog. But ultimately, I think the feeling is we can't really pause immigration. It's more of a measured basis. That's one of the pieces of feedback. I think we'll see more, as you say, aftermath. We know Quebec raised their hand and said, we're concerned that the feds have decreased the temporary foreign worker population too much, and we have skills shortages, and we'll not be able to meet our needs. So I think we're going to find pockets of individuals, whether it's provincial governments, it will be the opposition talking, but it will be a hot topic as to how this plays out.
Well, Noman, I think the problem is certainty. No one is really entirely sure how they're going to qualify in any of the categories. And there's a lot of uncertainty as to how programs are going to unfold, like the Startup Visa program, Express Entry, and even the provincial nominee programs, which seem to be getting more life in them.
Right.
But new streams are coming, and we haven't seen them yet.
And the other issue is we know there's a lot of pressure on processing times, but we didn't see a huge investment of money to hire officers to catch up on the processing. We did see some references to modernizing the digital systems.
Right.
And that might be interesting in terms of how they collate all the data and try to make sense of the different processes and potentially streamline, but not a lot of details as to how that's going to improve the current state.
Well, I have to believe that artificial intelligence and evaluating applications using logarithms is the future, because if you're not increasing officers, but in fact decreasing officers, but you're maintaining levels more or less the same as where they are, then the only answer to that is that something else has to review these applications. They're not going to be people.
Well, and interestingly, we've known historically immigration, CBSA, and CRA have talked about knowledge sharing, but we also see references of better sharing between the Temporary Foreign Worker Program and the IMP program. So the question is, at some point, will that data be looked at in a much more sophisticated way than it is right now? And what types of steps should employers consider as they move into a more digital approach to processing?
Okay, good questions. Time will tell. I think it's interesting for us to talk about a recent decision out of the federal court on an SUV case, because it's very instructive for the 17,000 applications which are, well, actually 17,000 certificates which are pending. Applications, of course, are much more numerous than 17,000. And that is what the obligations are of founders after they file their application for permanent residence and how much effort is needed. The case is cited in this week's ImmPulse as the first case. We actually recommend that you go to it and read it very carefully, because there's a lot of facts of the case. But what we take away from that case at a higher level is that reasonable decisions by officers will be upheld by the court, and a reasonable decision simply means looking at the facts and circumstances that have been presented by the applicant and understanding whether those facts and circumstances support whether there's a genuine intention to set up a business in Canada or simply acquire an immigrant visa. And although the regulations are not clear on what the test is and how you measure efforts by an applicant, the court says that's really not necessary. What is necessary is have the steps that you've taken credibly show on a balance of probabilities that you're setting up your business in Canada and you're doing it earnestly. You're doing it sincerely.
Yeah, and it was an interesting discussion if you look through the case. On one hand, there was a question raised as to whether or not these requirements are clear. Has enough been done? If a certificate's issued, you filed your application, and there was some business activity done in this particular business. However, the procedural fairness letters that were issued by the officer asked for specific evidence, and there was defects in some of that evidence.
Right.
Meaning there wasn't LinkedIn engagement, there were defects in the website. So yes, there was activity, but it wasn't sufficient to allow the officer to feel comfortable that the primary motivation was to run the business. The officer felt that the primary motivation was to get the visa.
So if your facts in your case that you're putting forward create suspicion, you've got a problem. Your facts should be providing strong evidence that your business is real and it will be set up. And it will be set up with an aim for substantial success.
Correct. And even more important in this current climate where we have a longer period of time of processing, that you have to be constantly updating, engaging your business and making sure that that information's gone over accurately to IRCC.
Well, we've turned to our clients. We have a substantial number of these SUV applications in process for a number of years. And we're saying to them quite candidly, review all your activities, record all your activities since the first day that we filed your PR application. Get ready that when that letter comes, the fairness letter, asking details about your setup, that you can show them pages of information, not a couple of paragraphs or a couple of lines.
Yeah. And I think we'll pay attention closely to updates to where the SUV program goes. Still unusual surprises. In our office, we just had an approval for an individual who had a regular certificate, non-priority.
Right.
And they received confirmation that they'll be a permanent resident. So a lot of moving parts, but I think if you have a tolerance to persevere, it's important that you understand the current climate and make sure you know the latest trends in the program.
It's not all negative. We just had an approval of a work permit. And you might want to describe the path that person took to get that approval.
Well, we were actually retained after the individual had been refused, ended up going to federal court, overturning that decision, refiling the application.
Striking out that decision.
Correct. Refiling the application with more updated information, making a fresh pitch, lining up all of the areas of concern previously, and we had an approval. And a number of other approvals too, where we've come in and really identified what the issue was and refiled with stronger information. So there is, opportunities to correct the record.
Right. If you have any questions about your application or you want some assistance in preparing your application, please feel free to reach out, and Aman and I would be pleased to speak to you. And you see, you missed the out of touch. Watch this. Did you see the eyebrows? That's the same. That's when you see the eyebrows
Can we
go up.
start the video with eyebrows?
Uh-oh.
I want to make sure I see clearly now. And for those of you that think that I'm toothless, that my argument has no teeth,